by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala, and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere and it is inconceivable that we can introduce it in Kenya. Mr. Raro was emphatic that our constitution provides for its alteration and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, learned counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yashpal Ghai and Jill Cottrell, Alicia Vernon, and James Gadhi, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution lest the spirit of the Constitution should create a legal theology. Dr. Otienda Amolo, senior counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned senior counsel asserted that even then, the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned senior counsel Professor Githu Muigai still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists and brought by people who have standing. To entertain such grievances and make such orders at large leads to an erosion of the dignity and sanctity of the court. And then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyo and the Learned Counsel for the National Assembly also urged rejection of the doctrine, but in the present case he considered, as he had to, that 74 amendments proposed in the BBI bill were numerous. He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel, Mr. Job Wambulwa, was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiko's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga, Land Council Mr. Ndegwa Njiru was equally opposed to the doctrine, and returning, he made reference to the Kivuitu, Priscilla Ndululu Kivuitu and another versus the Attorney General, and he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subjected to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as Land Counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the BBI proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit, and that changes to that core structure can only be effected through the exercise of constituent power with 4 features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, Counsel made reference to John Locke's 2 treatises of government and Baron de Montesquieu's The Spirit of the Laws, to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which, though not spelled out in the constitutional text, are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution, and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the Independence Constitution. He pointed out that Justice Ringera had acknowledged that but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate, successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Rosnai, counsel warned of the dangers of populist constitutionalism characterized by constitutional capture. He also refers to Dr. Mutaha Kangu's Constitutional Law of Kenya on Devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued in favor of the doctrine, adding that courts bear more than obligation to defend the Constitution as they are invested with the authority to defend it. He made a distinction between amendment and repeal by making reference to Black's Law Dictionary. So stating, he posited that the BBA initiative and Constitution Amendment Bill was an attempt to repeal the 2010 Constitution by implication. This is impermissible because the said Constitution is for eternity, which he explained to mean, quote, for as long as we have it. Next came Professor Kithure Kindiki Learned Counsel, who posited that there is a hierarchy of constitutional norms. And to demonstrate the basic structure, he posed the question whether one can amend the Constitution to change Kenya from a multi-party democracy into a constitutional monarchy, or alter its territory by having a part of it donated to another state, as had happened elsewhere in history. To him, such fundamental changes require a direct involvement of the people. He went on to say that the judges did not say that the basic structure cannot be altered, as the complaining appellant seemed to project, but rather that such changes must be subject to a deeper process involving the sovereignty of the people. He went on, indeed, appealing to us to dismiss the appeals with costs. He turned all spiritual, submitting that the BBI process was a botched attempt to overthrow the people and the Constitution, but, quote, by the mercy of Almighty God, the High Court intervened and declared it a nullity. Next came Dr. Mudhomi Nyankolu, who invited us to consider a quartet of questions. What kind of precedent do we want to create? What incentives for constitutional compliance will we put in place? How will future presidents treat the Constitution? Should we lend to this, according to him, illegality, judicial imprimatur? And how will politicians behave in the future? Resorting to Greek mythology, counsel implored us to recall the Hydra of Lerna, that multi-headed sea monster, which he likened to the impunity that has stalked this land, and urged the judiciary to be as steady as the sword as was the hero Heracles, and so slay it by upholding the judgment of the High Court. Learned Senior Counsel Dr. Kaminwa was categorical that the 2010 Constitution came about in answer to our rotten past and in response to global jurisprudence. Quoting from various books, he said that the 2010 Constitution was Kenya's way to sending a never again message to all that had gone wrong with us before. He declared that the Constitution is unamendable by the methods proposed in the BBI initiative and bill. The basic structure is not confined to India, but has spread worldwide. He was categorical that the problem in this country is not with the Constitution, but with ourselves, and especially with the politicians, quote, most of whom are mere job seekers who stand for absolutely nothing, end of quote. He urged us to throw out this appeal as unmeritorious. Equally scathing was Ms. Martha Karua, Learned Senior Counsel, who appeared for the professors of law who had been admitted as amici curiae before the High Court, positing that constitutions exist to limit the excess of authority. He lamented that in Kenya, the executive, state entities, and state officers ignore the fact. Stating that under Article 165, the courts can make determinations whether anything done is constitutional, he pleaded with us to hold that the Constitution is yet to be fully implemented as the final word on its interpretation. She asked us to mark the beacons for excesses of power by the executive and to, quote, uphold and protect the basic structure which is part of the DNA of the Constitution, end of quote. She was joined by Ms. Nyanguto, Land Council, who argued that the basic structure is inherent in the Constitution and urged us to uphold it and thus protect the Constitution from the BBI bill, which, quote, portends the death of the 2010 Constitution by 1,000 deadly cuts, end of quote. Coming next, Learned Counsel, Mr. Zebedeo Ongoya, argued that the judges did not merely import the doctrine from Indian case law, but rather found it in the history, text, and structure of the Constitution. In doing so, they developed a rich indigenous jurisprudence in a manner that was praiseworthy and not objectionable to deserve the attacks directed at them. He made reference to the decision of Lenaola J, which has been referred to in the Commission for the Implementation of the Constitution versus National Assembly. He went on to say that the learned judges were correct to delineate three types of sovereign power, namely primary constituent power, secondary constituent power, and constituted power germane to a determination of the questions at bar. This same theme was echoed by Learned Counsel Mr. Evans Ogada, who submitted that when the judges pronounced themselves on the basic structure doctrine, they were declaring a legitimate reality and were not merely engaging in lofty theory. Learned Counsel Mr. Ochel Dudley distilled three strange positions, according to him, that this court would have to simultaneously adopt in order for it to overturn the learned judge's findings on basic structure. Those three are: one, we would have to adopt textualism, we would have to elevate the political elite above the people, and finally, we would have to upset a settled theory of constitutional change. Referring to the case of Kesavananda, he indicated that our position is no less perilous than that faced the Indian courts, because we have 74 missiles that are trained at our constitution. To him, changing the constitution is not a normal state function, but an extraordinary authority. He pointed out that the power to amend is not authority to annihilate the constitution, which he warned could easily be abrogated by gradual amendments. He referred to the writings of Hans Kelsen to assert that the constitution is the Grun norm. It has to be accorded a more stable character. Thus, it is not enough for those intent on altering the constitution to just marshal the numbers, recalling that such formally compliant machinations have happened before. Learned Counsel Mr. Madenge took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine, because the Constitution has a core content and contains fundamental prior principles that are immutable in character. Making reply to all that, Mr. Nyamodi contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he conceded that Professor Rosnai is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya, and he seemed to suggest that it would be archaic and anachronistic to insist on a phenomenon from classical Greece where constituent power was exercised directly. Professor Muico, senior counsel, in reply, labeled this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments, and specifically the case law and academic writings presented to support the rival positions, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties left me wondering whether we had facts and alternative facts. Well, I will refrain from drawing any inference that any of the learned counsel before us were out to mislead the court, at least at this point, and give it the most charitable interpretation that texts sometimes speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb, and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and suppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mura, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for a more equitable share of resources and ensure that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting, the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to dry formalism in construction and obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that fealty to the constitutional text itself throws open the pathways of interpretation, to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights, and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It would be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights, and to be both faithful and fearless in the cause is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. this is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further exposition. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that persuades, indeed binds me, is a purposive and holistic one, which repudiates the text as the alpha and omega on the divination of the meaning and intent of the Constitution. One needs only cast a glance at our history of constitutional jurisprudence to see the long shadow cast by a textualist obsession as exemplified in Republic versus Elman back in 1969. That approach, thankfully long interred, although every once in a while we hear its ghost clanging its chains, seeking a place at the interpretative table, declared that the Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Mudhomi Ntiankolu's Landmarks from Elman to the Saitoti ruling, searching for a philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blazed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the Interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, The Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach, as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 2010 Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. The learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument, as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Menakea and others way back in 2017, where among other things we said the Constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental transcendental existence whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwana vandema miri makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances, and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head the extent and reality of presidential power by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the reality that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, it talks about aggregation of power, concentration, etc. So, that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions the very next year by the Constitutional Repeal of Restrictions Act of 1958, which was passed strictly in accordance with the prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. The proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of deja vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobweze then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power were systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it is made. I have laid emphasis on the last part of the commentary because, to my mind, the people of Kenya were quite clear that they were not going to cede the constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people, as creators of the Constitution, were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is with great respect quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of the people. It is not subject to the Constitution, which is but an emanation of it. This is the constituent power with which the people themselves, acting directly, can both make and replace a constitution. I've quoted Nabweze. The Njoya decision, which Ringera actually quotes Nabweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's ruminations on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The relevance of the constituent power to a discussion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he says, he gives an example of whether the Americans could decide and amend the first Constitution, the First Amendment, and replace it with an opposite fundamentally contradicting principle, such as establishing a state religion. Such a move would amount to a constitutional breakdown or revolution in the proper sense, and not a valid amendment of the Constitution. Professor Robert Albert, in an article called Constitutional Amendment and Dismemberment in the Yale University Law Journal of International Law, states that this Rawlsian view reflects the conventional understanding in the field of constitutional change. Either a constitution is amended consistently with the Constitution, or the alteration is so transformative that we cannot call it an amendment, and we must instead recognize that conceptually it creates a new constitution. Under that view, this would be the case even if the old constitution is not formally replaced with a new one. It can safely be argued that any amendment that alters the core aspects of a constitution, changing its character and ethos in a radical manner, is essentially changing its basic structure, and in all but word abrogates or dismembers the Constitution. The basic structure doctrine and the notion of constitutional dismemberment have the same effect of positing that such constitutional amendments are in fact unconstitutional. I've quoted the concurring opinion of Mr. Justice H.R. Khanna in Kesavananda. And I just want to mention that it's important to note that the Indian Constitution, just like ours, did not then and does not now contain unamendable provisions in its text. It lacks express limitations to its amendability. This is in contrast to some other jurisdictions in which the constitutions contain provisions prohibiting amendment of certain subjects, leading to the terminology, as Professor Raznai notes in his PhD thesis, the terminology of immutable, unalterable, irrevocable, perpetual, or eternal, all of which he considers, and I readily agree with him, to be inaccurate. Why? Because they imply everlasting provisions, but they are neither eternal nor unchangeable. While they serve as a mechanism for limiting the amendment power, they do not and cannot limit the primary constituent power. Moreover, their content can also change through judicial interpretation. The Brazilian terminology, which refers to these provisions as Petrus clauses, which I understand, that's me, which I understand to mean founded on rock. Petrus clauses, to express their rigidity, is more accurate in that respect, since even rocks cannot withstand the volcanic outburst of the primary constituent power. Therefore, in order to describe the legal situation more accurately, I refer to these provisions throughout this thesis as unamendable, as opposed to eternal or eternity clauses. The scholar notes that the technique of expressing prohibiting the amendment of certain state features, be they the form of government, separation of powers, or the like, spread like a fire in a thistle field, or, if you like, in the Gikomba clothes market, and was impelled in part to protect the Constitution by guarding against what he calls popular levity and legislative caprice. He then concluded that just as having a form of constitution virtually became a symbol of modernism following the American and French Revolution, so too nowadays having an unamendable provision is becoming a universal fashion. But importantly, he points out, which is germane to the analysis whether the learned judges were wrong in arriving at the conclusion they did, that the amendment power must be conceived as implicitly limited, even in the absence of any explicit limits. And he traces this back to the United States back at the dawn of the 19th century, refers to the works of John Calhoun in 1851, who wrote a book called Discourse on the Constitution and Government of the United States, and then also Thomas Cooley's Stories Commentaries in 1893. All these speak to the notion of intrinsic limitation to the amendment power, and it is not much different from the basic desire of Kenyans, I referred to earlier, that their constitution be altered only by the same means by which they made it. In Germany, the scholar Carl Schmitt was of the same view, that no revision of the constitution could provide for the destruction of its legitimacy. In short, the constitution does contain a core of implicitly unamendable principles which embody its identity. According to Rosenai, the argument in favor of implicit limitations on amendment powers did not remain in the realm of theory, but migrated from Germany to India in the 1960s, where, due to stormy political